Dear learners, welcome again to the undergraduate course on human rights, international humanitarian and refugee law. We have so far studied about the international regime of human rights and also about the regional mechanisms of human rights. Today, we are going to talk about sub-regional efforts to promote human rights within different regions. In this particular lecture, we are going to talk about the Arabs sub-regional organization, namely the Organization of Islamic States or OIC, and its initiatives towards human rights. So, let us begin. Regional initiatives for human rights emerged simultaneously to the United Nations initiatives to draft the Universal Declaration of Human Rights in 1948. Among several other factors, cultural relativism played a vital role in shaping this local articulation of human rights. There are established regional as well as sub-regional human rights systems in the world, and we can see cultural aspects in each of these systems. While the debate whether a universal approach is more desirable or a cultural one goes on, we have observed several regional human rights arrangements evolving in recent decades. Among the most recent ones is the Arab Initiative. The Arab human rights mechanism has been evolving under the aegis of the League of Arab States. However, in this lecture, we are going to discuss a sub-regional Arab approach to human rights within the Organization of Islamic Countries or OIC, and to discuss its contributions to the growth of the idea of sub-regional human rights protection, and also to assess if this effort is eroding the idea of universalism from its half-hearted approach towards human rights. The Universal Islamic Declaration of Human Rights or UIDHR 1981. The Universal Islamic Declaration of Human Rights or UIDHR was led by Islamic Republic of Iran in 1981, 2 years after the Iranian Revolution. In the same year 1981, the Universal Islamic Declaration of Human Rights or UIDHR was presented to the United Nations Educational, Scientific and Cultural Organization or UNESCO in Paris. It was prepared under the auspices of the Islamic Council, a London-based organization which was affiliated with the Muslim World League MWL, an international non-governmental organization NGO, which has its headquarters in Makkah, the Kingdom of Saudi Arabia. The declaration asserts that the concept of human rights was of divine origin and human dignity could not be reduced to a series of secular norms, hinting that the United Nations Universal Declaration of Human Rights UDHR was not respecting the Islamic approach to human rights, and thus certain concepts contained in the Universal Declaration of Human Rights needed to be revised. It was emphasized that the declaration is contrary to Islam and that it had no validity in the Islamic countries. They include that the Universal Declaration of Human Rights represents a secular understanding of the Judeo-Christian tradition. Thus, it could not be implemented by the Islamic countries. The Cairo Declaration of Human Rights in Islam, CDHRI, in 1990. In this background, there was felt a need for an Islamic expression of human rights. The Cairo Declaration on Human Rights in Islam, CDHRI, 1990, was adopted in Cairo on 5th August 1990 by the OIC during the 19th Islamic Conference of Foreign Ministers. The session was named as Peace, Interdependence and Development. This conference was attended by 45 member states of the OIC. The Cairo Declaration establishes the Sharia law as the only source of reference for the protection of human rights in Islamic countries. The CDHRI or the Cairo Declaration was presented for approval at the OIC summit meeting of heads of state and government held in Dakar, Senegal on 9th December 1991. However, this was averted following a press release from the Geneva-based International Commission of Jurists. Despite the aversion, The Cairo Declaration was published in December 1997 by the Office of the High Commissioner for Human Rights in Volume 2 of International Instruments, which gives it a certain authority. In the early 2010s, the OIC began revising the instrument and introduced the OIC Declaration on Human Rights, ODHR, almost a decade later. The document was scheduled to be approved at the organization's Council of Foreign Ministers (CFM) meeting in April 2020. However, this was cancelled due to the COVID-19 pandemic. Although the ODHR better reflects principles rooted in the international human rights law, it falls short on issues related to family values, freedom of speech, and political participation. The evolution of the Cairo Declaration is encouraging, although. Major criticisms faced by the Cairo Declaration were that, firstly, from an international human rights perspective, the OIC stirred controversy because the Cairo Declaration claimed adherence to Sharia, and the Cairo Declaration never specified what the term Sharia constituted. Secondly, the declaration did not recognize freedom of assembly and association or protect women from discrimination. Indeed, Article 12 provided the right to freedom of movement solely to men, while Article 6 declared them as being the head of the household. And thirdly, the biggest flaw of the Cairo Declaration was its empowerment of states over individuals. The OIC has paid attention to criticisms of the Cairo Declaration. According to a document released by the organization, it is recognized that there are obvious legal, linguistic, and perceptual gaps and inconsistencies in the Cairo Declaration, which require careful screening and review to make it more practical, representative, broad-based, and above all, implementable. This attitude reflects the process of reform that the organization carried out in the mid-2000s. The OIC adopted its 10-year program of action in 2005 and revised its charter in 2008, with changes made to reassert a commitment to human rights. During this period, the organization reduced the focus and mention of Sharia in its human rights documents, referring instead to Islamic values more broadly. For example, in the Covenant on the Rights of the Child in Islam of 2005, the OIC invoked Sharia, yet Islamic law was framed as the broad set of values that informed the document was not used to curtail universal freedoms. Having taken it one step further, the Plan of Action for the Advancement of Women, or OPAAW of 2016, did not refer to Sharia at all, but mentioned Islamic values several times. For instance, the introduction stated that through OPAAW of OIC is taking steps towards eliminating all forms of discrimination against women in order to reduce inequalities between women and men, pursuant to Islamic values of social justice and gender equality. More significantly, the OIC established the Independent Permanent Human Rights Commission (IPHRC) in 2011. The body lacks power to investigate human rights violations or enforce its decisions, nor does it have the resources for effective human rights monitoring. While minority rights is still an issue, the Commission has institutionalized human rights discourse within the OIC and become a focal point of advocacy. The OIC drafted the ODHR so that it draws closer to the international human rights norms. For instance, the document increases women's rights, specifically through Article 5, which declares that state and the society shall take all necessary measures to eliminate difficulties that impede the empowerment of women, their access to quality education, basic health care, employment and job protection, and the right to receive equal remuneration for equal work, as well as their full and effective participation in all spheres of life. The article adds that women and the girl child shall also be protected against all forms of discrimination, violence, abuse, and harmful traditional practices. Moreover, the ODHR does not establish husbands as the head of the family. Despite such advancements, the OIC still failed to comply with various international norms. For example, the ODHR, like its predecessor, omits many rights including the freedom of peaceful assembly and association and universal suffrage. This unsurprisingly reflects the predominance of authoritarian political systems among member states rather than Sharia morality or jurisprudence. The document also defines marriage between a man and a woman and asks member states to protect family and marriage, thus demonstrating the conservative influences described all over in this lecture. The ODHR also falls short in the area of LGBTQ rights. Furthermore, freedom of expression is not included in ODHR. The preamble states that the need to protect the rights of communities and preserve their dignity and religious and cultural identity. The ODHR marks an improvement from the 1990 Cairo Declaration as it aligns more closely with the UDHR and offers a contemporary formulation of Muslim state positions on human rights. Moving forward, if the OIC and the international community seek to further human rights in the Muslim world, they should focus on implementation, diplomacy, and involving civil society. Regarding implementation, the OIC should continue to refine its human rights vision and, more importantly, move to implement basic freedoms with binding treaties and monitoring. It should also help member states build their human rights capacity. On the part of the international community, it can and should collaborate with member states and their NHRIs more specifically to realize ODHR principles that already align with those of the UDHR. Now, let us have a look at the OIC human rights instruments and mechanisms. The OIC has attempted to base its perception of human rights on several sources like the OIC Charter, the OIC 10-Year Program of Action (TYPA), Islamic Humanitarianism, Independent Permanent Human Rights Commission (IPHRC), OIC Plan of Action for Advancement of Women, Covenant on the Rights of the Child in Islam. These all are discussed ahead in this lecture. The new OIC Charter presented the institutional reform program which was initiated in 2005. Although the legitimacy of human rights is recognized on the first OIC Charter adopted in 1972, the new Charter gives a greater normative and institutional role for the human rights in the OIC. This Charter is devoted to promote human rights and fundamental freedoms, good governance, rule of law, democracy and accountability, and protecting and endorsing the rights of women and their participation in all domains of life in member states in accordance with domestic legislation, which is also seen to be a drawback in itself. The new Charter is clearer, though, to uphold human rights as it mentions unambiguous obligations on members. For example, the OIC members are to promote and safeguard human rights and major freedoms including the rights of women, children, youth, elderly and people with extraordinary needs, as well as the conservation of Islamic family values. 10-Year Program of Action or TYPA. This instrument, adopted by the OIC heads of state and government in 2005, acts as a cornerstone of the institutional reforms embarked on in the year. The TYPA has developed with the awareness of the potential for the Muslim world to realize renaissance and to take practical stages towards consolidation, the connections of Islamic unity, achieve union of ranks and project the correct image of noble values of Islam and its civilizational attitudes. As part of a larger development of the OIC, the TYPA introduces a clear concentration on universal human rights and the significance of mainstreaming them into all programs and accomplishments specifically on human rights and democracy. Islamic humanitarian intervention. The Islamic Cooperation Humanitarian Affairs Department, ICHAD, was established in 2008 in order to look after the humanitarian issues and what OIC needs to do. Under the Humanitarian Affairs Department, the OIC has given importance to the matter of disaster risk reduction and the obligation to reduce the loss of life, livelihood and economic properties through natural disasters, an initiative which searches for acceleration of the universal operation of the HuR-L30 framework of action 2005-2015 and the growing role of disaster risk reduction efforts and initiatives it is playing in the OIC members' national policies. In this manner, ICHAD, which is the OIC principal point, closely cooperates with the League of Arab States and other institutions, for example, of the Saudi Arabian Presidency of Meteorology and Environment and the Islamic Development Bank. At the time that OIC is emerging as a significant humanitarian actor, the OIC has also advanced partnerships with the official humanitarian sector, including the United Nations Secretariat, the World Food Programme WFP, the United Nations High Commissioner for Refugees UNHCR, and the UN Office for the Coordination of Humanitarian Affairs OCHA. From the perspective of the formal humanitarian sector, these partnerships not only symbolize an acknowledgement of the developing role of the OIC, but also an optimism that the latter's Islamic identity can assist in developing new tactics to humanitarian action in the Muslim world and facilitate access to the zones controlled by the Islamist movements, opposed to the provision of aid by a system that is largely seen as Western, which is by United Nations. The Council of Foreign Ministers of OIC, by its resolutions in 2011, commends the efforts made by the Humanitarian Affairs Department to alleviate the sufferings of the needy people in different OIC member states struck by disasters and calamities, particularly in Gaza, Libya, Somalia, Niger, Yemen, and so on. It also appreciated the work done by the OIC funds in Afghanistan, Bosnia-Herzegovina, and Sierra Leone. Let us talk about the OIC Independent Permanent Human Rights Commission, IPHRC. The Commission's founding statute was adopted in 2011 as per the Charter of the OIC. Article 15 of the Charter stipulates the broader mandate of the IPHRC as promoting the civil, political, social and economic rights cherished in the organization's covenants and declarations and in universally agreed human rights instruments in conformity with the Islamic values. According to the statute of the Commission, its mandate is limited to carrying out consultative responsibilities for the Council of Foreign Ministers and submitting recommendations to it rather than investigation human rights violations in member countries or undertaking protective functions. The IPHRC is composed of 18 specialists of well-known distinction in the issue of human rights. 6 members from each geographical region group, Africa, Arab and Asia, represented in the OIC, nominated by member states and nominated by the Council of Foreign Ministers for a period of 3 years. It is pertinent to note here that the establishment of IPHRC symbolizes the increasing prominence of human rights and institutional reforms within the OIC and its desire to increase its relevance and legitimacy among the peoples of member states and endorse its credibility at the international level as well. According to a report of the Asia Forum 2014, OIC Commission on Human Rights as an initiative is growing its influence in countries like Turkey, Morocco, Indonesia and Malaysia, whose approach to human rights may differ from the traditional players of the OIC members like Saudi Arabia, Iran and Pakistan. On 21st March 2021, the OIC Commission joined the international community in observing the International Day for the Elimination of Racial Discrimination 2021 and reiterated the importance of recognizing, addressing and eradicating all forms of racism and ethnic oppression across the world. The body emphasizes the role of Islam in this context, and it says, the Commission underscored that Islam categorically prohibits all forms of racism, discrimination and intolerance. It is among the fundamental principles of Islam that all people are equal and enjoy equal rights and responsibilities, regardless of their caste, creed, color or faith. Combating racism entails respect for diversity, multiculturalism, inclusiveness, democracy and the rule of law, which are core values needed to enjoy human rights and fundamental freedoms by all. OIC Plan of Action for Advancement of Women. In order to achieve the goals set in the 10-year program of action, OIC adopted the statute of OIC Women Development Organization in May 2009, with the sole purpose of promoting women rights in the member countries. The organization, which is based in Cairo, Egypt, is expected to work for the development and promotion of the role of women in the OIC member states with capacity, talents and competence building through various mechanisms including training, education and rehabilitation in line with Islamic principles and values. In Article 5, Clause 1 of the founding statute of the OIC Women Development Organization announces that it should highlighting the role of Islam in preserving the rights of the Muslim women, especially at the international level. Organizational objectives and mandate outlined in the statute do not allow OIC Women Development Organization to engage directly in the women's rights discourse with the OIC member countries. Instead, its objective appears to be facilitating women's participation in development and countering the negative stereotypes of women in Muslim societies. Finally, safeguarding and endorsing the rights of Muslim minorities in non-OIC countries is one of the primary responsibilities and objectives of the OIC. OIC's engagement with situations involving Muslim minorities has been oriented towards mediation, conflict resolution and providing humanitarian support rather than direct intervention on issues related to human rights violations. In Asia, OIC's involvement had in the past been visible in their mediation efforts in the Philippines and Thailand between the governments and Muslim separatists. Efforts to resolve the communal conflict in Myanmar between Rohingya Muslims and the majority Buddhists have been particularly important. The OIC-WDO held its 7th Ministerial Conference on the role of women in the development in the OIC member states in the session of Women Empowerment in Member States Challenges and Prospects. It was held in Burkina Faso from 30th November to 1st December 2018. However, the question remains whether OIC is open to hold itself to the same standards it demands from the non-member states when it comes to Muslim and non-Muslim minorities in OIC states, given increasing reports of abuse of the rights of such minorities in many OIC member countries. The ambit of OIC Plan of Action for Advancement of Women has increased with the passage of time. There is no doubt that for better compliance of human rights, the regimes must be culturally constructed, which further means they must be articulated keeping in context the historical, political, cultural background of the country or the region. However, while doing that, the universal values must be upheld. For example, basic rights cannot be denied in the name of religion or religious practices. The problem within the OIC over human rights understanding has been highlighted by Turan Kuglo in following excerpt. Most OIC leaders believe that human rights should accommodate Islamic values. There are three groups within the OIC leadership: radical relativists who deny any legitimacy to the United Nations human rights system. Secondly, strong relativists who argue for the compatibility of Islamic and universal human rights to some degree, but ultimately prioritize Islamic compatible rights while interpreting universal rights and rejecting universal rights in the instances of apparent conflict. And thirdly, moderate universalists who also argue for the compatibility of Islamic and universal human rights, but prioritize universal human rights and are thus more willing to interpret Islamic values in a way to make them conform to the universal rights in instances of conflict. Such a situation points at a hopeful position of the Islamic human rights system because there is presence of a more holistic approach towards human rights. It might take a little more time to come to fruition, though. It is not important to embrace Western particularities of human rights narrative in the Islamic narrative of human rights. Rather, one must look forward to a unique model presented by the Islamic world. That would be actual contribution in making the human rights holistic. The Cairo Declaration of Human Rights in Islam was presented to the United Nations in 1992 and it was accepted into Human Rights Commission's compilation of international instruments in 1997. This action is arguably viewed as a consecration of the document by the United Nations, that is, by virtue of resolution number 49/19-P on the Cairo Declaration on Human Rights in Islam. Since then, the Cairo Declaration of Human Rights in Islam, CDHRI, has formed a part of the International Instrument on Human Rights. Creation of international law of blasphemy is also very interesting to note. Although the status given to the document is that of a regional instrument, the universality of its application across globe cannot be disputed. This is so because its sponsor, which is the OIC, is a universal body comprising 56 states of the world. Moreover, the CDHRI has been observed as the sole legal source behind the modern proclamation of international law of blasphemy by the United Nations. The UDHR or any other international instrument does not contain provision for international law of blasphemy. This is, however, one of the effects of its publication by the United Nations Human Rights Commission. The Defamation of Religions resolution of 2005 was brought to the Human Rights Council by the OIC with the intention of protecting all religions from defamation, thus making a blasphemous act a human rights violation and a crime. The United Nations Human Rights Council adopted the resolution by a vote of 21 to 10 regardless of several EU countries' concern that religious defamation laws would be used to limit freedom of speech. The Covenant on the Rights of the Child in Islam entered into force on 28 June 2005 as it was adopted by 32nd Islamic Conference of Foreign Ministers in Sana'a, Republic of Yemen in June 2005. Article 24 of the Covenant provides for the implementation mechanism of the Covenant. It says, states party to the present Covenant agree to establish an Islamic Committee on the Rights of the Child. The committee shall be composed of the representatives of all the state parties to the present Covenant and shall meet every 2 years, starting from the date of entry into force of this Covenant, at the headquarters of the OIC to examine the progress made in the implementation of this Covenant, and the proceedings of the meeting, for which 2/3 of the state parties to the present Covenant shall constitute a quorum, shall be governed by the rules of procedure for the meeting of the conferences of the Organization of the Islamic Conference. The Covenant appears to be a step in the right direction. However, it fails miserably once analyzed. The very first article of the Covenant fails to define who is a child and simply mentions a child means every human being who, according to law applicable to him or her, has not attained majority, thus leaving it to the parent state to deal with the question. Further, in Article 3, it mentions that the Covenant is to observe non-interference in the internal affairs of any state, which again leaves child victims at the mercy of the state. There are concerns which are not addressed in the Covenant related to the children in armed conflicts and their rights vis-a-vis armed forces. The Islamic interpretation of human rights would not only be followed by the Arab countries, but a significant part of Africa, South Asia, as well as Southeast Asia, and everywhere where we have followers of Islam and practitioners of human rights. We must give OIC more time to come up with a more effective mechanism and more embracing human rights approach, with the hope that all human rights initiatives will bring good to the quality of human life. That should be all for this lecture. Take care and bye for now.